It's a Tuesday night. Nothing about it feels different from any other Tuesday. Maybe you grabbed food on the way back. Maybe you were at a friend's place. Maybe you finished a shift that ran long, and all you want is to get home. The roads are mostly empty, music on low, your mind is somewhere else entirely. Then it happens. Blue lights, red lights. Your rearview mirror just lit up, and your stomach drops immediately. Even though your hands were on the wheel the whole time, even though you weren't speeding, even though you did absolutely nothing wrong tonight, it doesn't matter. Those lights do something to a person that pure logic can't explain. Some kind of deep, automatic response that hits before you even have a chance to process it. You pull over, cut the engine, roll the window down. The officer walks up. Flashlight sweeps across your face. He says something minor. Your registration sticker, a brake light. You allegedly drifted slightly back there somewhere. Whatever it is, it's small. This should be nothing. License, registration, maybe a ticket, and you're home in 10 minutes. You hand everything over. You answer his questions calmly. You're being cooperative. You're giving him absolutely no reason to look at you twice. And then he stops. He looks at you, really looks at you. And he asks something that catches you completely off guard, even though honestly it shouldn't. 4 words. Mind if we search? And this is the moment, right here, this exact second. Because what comes out of your mouth next isn't just about tonight. What you say or don't say in the next 30 seconds can shape everything that follows. And the gut-wrenching part is that most people sitting in that driver's seat have absolutely no idea what the right answer is. Nobody taught them. It was never covered in driver's ed. It never came up at home. And so they do what feels natural under pressure. They say yes. They say yes because they think it proves they're innocent. They say yes because they're nervous and they want this to just be over. And yes feels like the fastest exit out of a situation that feels suffocating. They say yes because somewhere in the back of their mind, they genuinely believe that refusing makes you look guilty. But here's what nobody tells you. The moment you say yes, the moment that word leaves your mouth, you have voluntarily handed over one of the most significant legal protections the United States Constitution gives you. 2 syllables. Gone. Now think carefully about what actually happens after that. The search begins. And here's the part that should genuinely concern you. It doesn't matter that you believe your car is completely clean, because once you've given consent, the rules change entirely. What started as a minor traffic stop is now an officer going through your glove compartment, pulling things out of your center console, checking under your seats, opening your trunk. And the scope of that search is not determined by what you intended to allow. It's determined by how broadly the officer chooses to interpret the permission you gave him. Maybe there's truly nothing there. Maybe you walk away 20 minutes late, shaken but fine. But maybe there's an old prescription bottle in the back that doesn't have a readable label anymore. Maybe there's a pocket knife your brother left in your car months ago that you completely forgot about. Maybe a friend borrowed your car last week and left something in the back seat that you have never once looked at. And maybe, even if everything in that car has a perfectly innocent explanation, an officer who is already searching, already looking for something, starts asking questions that don't have simple answers when you're trying to explain them under pressure, at night, on the side of a road, with your hands slightly unsteady. This isn't a story designed to make you paranoid. This is a pattern that plays out in traffic stops every single day, to regular people. People who did nothing wrong. People who said yes because they didn't know they could say no. Or more precisely, because nobody ever sat them down and explained how to say no without making things worse. Because here's the truth you need to hold on to right now. Saying no is completely 100% legal. It is your constitutional right. Refusing a search request does not make you guilty of anything. It does not, on its own, give an officer independent legal justification to search your car anyway. And it absolutely does not mean you're going to be arrested for saying it. But tone matters. Words matter. The way you say it matters enormously. Say it the wrong way, with attitude, with an argument attached, with hostility, and you've created a problem that didn't exist 30 seconds ago. Say it the right way, calm, clear, brief, and you've protected yourself without escalating a single thing. So, what would you do if that officer was standing at your window right now? Not after you've thought it through. Right now. Lights still going, his eyes on you, waiting for your answer. By the time we're done here, you'll know exactly what to say, and you won't forget it. Before we get to the words themselves, you need to understand the legal foundation underneath all of this. Because if you don't understand why it works, you won't trust it enough to actually use it when the pressure is real. When a police officer asks for your consent to search, he is asking because he does not currently have independent legal authority to conduct that search. Let that land for a second. If he already had the right to search your vehicle, if there was a valid warrant, if he had observed something that legally justified a search, if probable cause already existed, he would not be asking. He would be telling you, "Sir, step out of the vehicle. We're going to search the car." That is a statement of authority. that is a different conversation entirely. But when it's phrased as a question, with your agreement being sought, that is because your consent is what he needs in order to proceed lawfully. The Fourth Amendment to the United States Constitution is the source of this protection. It prohibits unreasonable searches and seizures by government actors, which includes law enforcement at every level. Without a warrant, without your consent, or without a recognized legal exception, an officer cannot search your vehicle during a routine traffic stop. That is not a gray area, that is settled constitutional law. Now here's where I have to be completely straight with you, because giving people an incomplete picture of their rights doesn't protect them. It leads them into situations they weren't prepared for. There are legitimate legal exceptions to this protection. You need to know every one of them. Probable cause is the most important exception you will encounter in a traffic stop. If an officer has a reasonable, articulable basis, grounded in specific facts he has actually observed, to believe that contraband or evidence of a crime is present in your vehicle, that can legally justify a warrantless search without your consent. The smell of marijuana coming from inside the car, a controlled substance or weapon visible in plain sight on the seat. These are real, court-recognized bases for a search that your refusal alone cannot stop. Understand this clearly. Saying, "I don't consent," does not automatically halt every search in every circumstance. When genuine probable cause exists, the officer may legally proceed regardless of your position on consent. If you are being lawfully arrested, officers can search the area within your immediate reach without your permission. This is called a search incident to a lawful arrest. It exists for officer safety and to prevent the destruction of evidence. It applies when the underlying arrest itself is lawful. The plain view doctrine allows an officer who is lawfully positioned to seize contraband or evidence of a crime that is clearly visible to him. The word lawfully carries enormous weight there. He cannot manufacture a plain view observation by accessing areas he has no legal basis to be in. If your car is being impounded, an inventory search can be conducted without your consent. This is administrative in nature, documenting your property for liability purposes, and it does not require your agreement. And in genuine emergency circumstances, someone's life is at immediate risk, evidence is being actively destroyed in front of the officer, a suspect is actively fleeing. Officers can act without a warrant under what courts call exigent circumstances. These are real exceptions recognized by courts. Know every one of them. But here's the practical point that matters most in the context of a routine traffic stop. With no drugs or weapons visible, no criminal odor coming from the vehicle, no warrant, no arrest in progress, none of those exceptions automatically apply simply because you got pulled over for drifting or a brake light. The stop authorizes the officer to address the specific traffic matter. That is the legal boundary of what that stop allows. When he asks to search, he's asking because your voluntary consent is the only lawful pathway he currently has to go beyond that boundary. And the vast majority of drivers have no idea this is the dynamic playing out right in front of them. One more thing worth being precise about. Some people think that consenting to a partial search, you can look in the front but not the back, somehow protects the rest of the car. Courts are not consistent on this. A general verbal consent to search a vehicle is frequently interpreted broadly. The cleaner legal position is to decline entirely rather than attempt to negotiate the scope of consent, because partial consent is a blurry line you do not want to be standing on when things go sideways. Now here's the part most people never see coming, and it's the part that causes more failed refusals than anything else. You decide to say no. Solid decision, legally sound. But the officer doesn't simply accept it and wrap up the stop. He keeps going. And this is where most people's resolve collapses. Not because their rights disappeared, but because they weren't prepared for what the conversation looks like after no. There is a sequence to how these interactions typically unfold. Once you see it laid out clearly, it stops having power over you. The first move is almost always the casual ask. The phrasing is deliberately relaxed. "Hey, you mind if I just take a quick look?" Not formal language, not a legal declaration, just quick look, delivered like it's the most normal thing in the world. Like it would be slightly strange to make a big deal out of it. The psychology behind this isn't complicated. Most people have a deep-seated reluctance to refuse a polite request from someone in authority. Saying no to something framed that casually feels uncomfortable, almost impolite. And that discomfort is not accidental. It is entirely the point. The second move is subtler and honestly more effective on most people. The officer shifts from asking to implying the search is already decided. "I'm going to need to take a look at your vehicle. Can you step out for me?" Read that carefully. He didn't ask whether you agree. He stated what is going to happen, then asked you to cooperate with a process already framed as in motion. Many people hear that and genuinely conclude they have no choice, that the decision was made before they had any say in it. Sometimes that's true, because genuine legal authority exists. Often, it isn't, and you are allowed to ask, calmly, without any confrontational edge whatsoever. Do you have a warrant or probable cause for a search? That is a legitimate question. Not a challenge, not an argument, simply a request for the legal basis of what is being asked of you. The third move is the one that works on almost everyone, the nothing to hide framing. Look, if you've got nothing to hide, this takes 2 minutes and you're on your way. It sounds logical. It sounds like the sensible, low drama path through an uncomfortable moment. But think carefully about what that argument actually requires you to accept. That your constitutional rights only matter when you have something to hide. That an innocent person should have no objection to waiving a legal protection. Courts do not operate that way. The Fourth Amendment contains no nothing to hide clause. Your right to privacy exists regardless of what is or isn't in your car, and invoking it does not imply that anything is wrong. The fourth move works on your nervous system rather than your intellect. Extended time. The officer goes back to his cruiser and takes a long time. He comes back and asks follow-up questions. Where are you headed? Where are you coming from? Who are you with tonight? Some of this may be legitimate inquiry. Some of it is designed to keep you sitting in an uncomfortable situation long enough that you eventually agree to the search just to end it. You should know that once the original purpose of the traffic stop has been completed, once you've received your ticket or warning and your documents have been returned to you, the legal authority underpinning that stop may have run its course. At that point, the right question is, am I free to go? If yes, leave. If no, that has its own legal implications we'll get to. The fifth move comes after you've already said no. The officer looks at you and says, "Why not? What are you hiding?" That is a pressure tactic, not a legal argument. Courts have addressed this specifically. Refusing consent to search does not, standing alone, constitute probable cause for a search. Your refusal does not establish reasonable suspicion. What this tactic is designed to do is trigger your instinct to explain yourself, to justify your no, to prove through words that you're innocent. And the moment you start doing that, you have entered a negotiation you never needed to be in. You do not owe an explanation. Stating a constitutional right requires no justification whatsoever. The canine announcement needs its own careful explanation. I'm going to bring a drug dog over. For most people, those words feel like a wall coming down, like the search is now inevitable regardless of anything they said. Here is the accurate legal picture. A dog sniff of the exterior of a vehicle, conducted during a lawful traffic stop, has generally been upheld by courts as permissible without a warrant. That part is true. However, the Supreme Court's ruling in Rodriguez v. United States, 575 U.S. 348, decided in 2015, established something critically important. An officer cannot extend the duration of a traffic stop beyond the time reasonably necessary to complete its original mission, issuing the ticket, running the standard license and warrant check, solely for the purpose of waiting for a canine unit, absent independent reasonable suspicion of criminal activity. The key phrase there is reasonable suspicion of criminal activity, something specific and articulable beyond the original traffic violation itself. If the stop is being stretched out with no independent basis, that prolongation may be unlawful. That does not mean you resist. It means you note it calmly, state clearly that you do not consent to any search, and preserve your ability to challenge it afterward through a lawyer and through proper legal channels. If a canine does alert on the exterior of your vehicle, that alert can establish probable cause for a search. At that point, stay completely calm. Do not resist in any way. State clearly and calmly on the record that you do not consent, and let what follows be addressed by an attorney in a courtroom where it belongs. Now let's talk about passengers, and specifically about passenger belongings, because the accurate legal picture here is more nuanced than most people realize, and I want to be precise with you. If you are a passenger and the driver consents to a search of the vehicle, that consent covers the vehicle itself. In a situation where no independent probable cause exists for the vehicle, the driver's consent alone does not automatically authorize a search of your personal belongings, your bag, your backpack, your jacket. Personal items that clearly belong to you as a passenger carry their own consent requirement tied specifically to you. In that scenario, if an officer reaches for something that is clearly yours without asking you directly, you can and should calmly state, "Officer, that belongs to me personally. I do not consent to a search of my belongings." However, and this part is critical to understand, if the officer already has probable cause to search the vehicle itself, such as detecting the odor of narcotics or seeing contraband in plain view, courts, including the Supreme Court in Wyoming v. Houghton, 526 U.S. 295, decided in 1999, have held that probable cause to search a vehicle extends to containers within that vehicle that could reasonably contain the object of the search, including bags belonging to passengers. What this means practically: asserting that your bag is personal property is meaningful and legally relevant when the officer is relying solely on the driver's consent and nothing else. It is not a guaranteed shield when the officer has independently established probable cause to search the vehicle. In that situation, the bag may be searched regardless of your position on consent. State it clearly, state it calmly, understand the limits of what it protects, and know that anything that happens afterward is something to address with a lawyer. Now, here are the actual words. Because know your rights as advice is genuinely useless if nobody tells you what to say when you're sitting in a car at night with your heart pounding and an officer at your window waiting for your answer. The phrase is this: "Officer, I don't consent to searches." 5 words. No explanation attached, no apology, no defensive elaboration. "No, but I want you to know I have nothing to hide," added because you want him to think well of you. Just those 5 words in a calm and level voice with normal eye contact. Say them out loud right now. Seriously, right now. "Officer, I don't consent to searches." Notice how completely neutral that sounds. There is nothing confrontational in those words, nothing disrespectful. It is not a challenge. It is a brief, clear statement of a legal position. The same way a lawyer saying, "My client invokes the Fifth," isn't picking a fight with anyone. They're asserting a protection that exists. That's exactly what this is. Here is the complete approach, step by step. From the moment you pull over, communicate calm cooperation through everything about how you carry yourself. Hands visible on the steering wheel. No sudden movements of any kind. Window all the way down. When the officer asks for your license and registration, announce it before reaching. "My registration is in the glove box. Okay if I reach for it?" That one sentence prevents any ambiguity. It starts the interaction with you being cooperative rather than defensive. It matters more than most people realize. Hand over your license, registration, and proof of insurance without hesitation. These are legal requirements in every state. This is not the moment to assert anything. Give him exactly what he is legally entitled to ask for, fully and promptly. When the consent question comes, in whatever form it takes, the response does not change. "Officer, I don't consent to searches." When he asks, "Why not?" your answer is, "I'm not comfortable with searches, but I want to cooperate with everything I'm legally required to." You are not picking a fight. You are making one specific legal assertion while making it equally clear that you intend to comply with every actual legal obligation placed on you. That distinction matters in how the rest of the interaction unfolds. When he says he is going to search regardless, your response is, "Officer, I want to be clear. I do not consent to this search. If you have probable cause or a valid warrant, I understand that, and I will not resist. But I want it on the record that I did not give my consent." And then, non-negotiable, you do not physically resist. You do not put your hands on the officer. You do not attempt to block access to the vehicle. Whatever happens from that point is something to address through a lawyer, through a courtroom, through the legal process that exists precisely for situations like this. Your job right now is to get through this encounter safely, with your legal position clearly stated and documented, and your options fully preserved. 2 questions belong in your toolkit. Know both of them cold. Am I free to go? Ask this calmly once the purpose of the stop seems to have been completed, and the officer is still lingering, still questioning, still requesting consent to search. If the answer is yes, leave. Don't stay to make a point, just leave. If the answer is no, am I being detained? If you are being detained, the officer has a legal obligation to have a basis for that detention. You are entitled to know what that basis is. In most states, recording a police encounter in a public space is lawful as long as you are not interfering with the officer's duties. Keep it completely non-confrontational. Phone visible, recording, resting on your lap or on the dashboard. Mention it simply. "I'm going to record this for my records." Nothing more. No editorial. Let it run. Beyond your identification documents, you have no legal obligation to answer questions about your destination, your activities, your passengers, or what you were doing earlier. I prefer not to answer additional questions. That is a complete and sufficient answer. These are the phrases worth genuinely memorizing. Not reading once and moving on. Actually memorizing. The way you'd memorize something you know you'll need when your mind is under pressure and working against you. "Officer, I don't consent to searches. Am I free to go? Am I being detained? I want to cooperate with everything I'm legally required to. I don't consent, but I won't resist if you have a lawful basis. I prefer not to answer additional questions. I'm going to record this interaction." The version of you that fumbles in that moment, that says, sure, I guess, when everything inside you is saying no. That version simply didn't have these words ready when they were needed. That's not a character flaw, it's a preparation gap. That gap is now closed. Let's go through the harder scenarios, because real situations rarely look exactly like the straightforward example. You're a passenger. Your friend gets pulled over and says yes before you can say a word. The officer starts going through the car and moves toward your backpack sitting in the back seat. Here is the accurate picture. If the officer is relying solely on the driver's consent and there is no independent probable cause for the vehicle, no odor of narcotics, nothing in plain view, nothing independently establishing probable cause, then the driver's yes does not automatically authorize a search of personal items that are clearly yours. In that scenario, you can calmly say, "Officer, that bag belongs to me personally. I don't consent to a search of my belongings." Stating this clearly creates the legal record. However, if the officer has independently established probable cause to search the vehicle itself, such as detecting the odor of a controlled substance, courts have recognized that probable cause for the vehicle can extend to containers within it, including passenger bags. In that situation, asserting your non-consent is still meaningful for the legal record, but it may not prevent the search from proceeding. State it, document it, and address what follows with an attorney. Your front door. Officers cannot lawfully enter your home without a valid warrant, your consent, or genuine exigent circumstances, a real immediate emergency. When they knock and ask to come inside and just talk, they are asking because they need your permission. You are not legally required to open your door beyond what you are comfortable with. You can speak through a partially open door. You can say, "Do you have a warrant?" If they do, ask to see it and read it carefully before making any decision. A valid warrant specifies the address to be searched and what they are authorized to look for. If they don't have one and they're requesting consent, the same response applies. Your safety during a stop. If you are pulled over at night and something about the situation feels genuinely unsafe, not just uncomfortable, but truly threatening, here is the advice that is both safe and legally sound. Pull over as soon as you safely and reasonably can. This is the first obligation. In every state, you are required to pull over promptly when signaled by law enforcement. Failure to do so can constitute a separate criminal offense, regardless of any other circumstances. If you are on a highway, an unlit road, or an isolated stretch, and you are genuinely concerned about your safety at that specific location, the accepted approach is to immediately turn on your hazard lights to clearly signal to the officer that you have seen him and are complying. Slow down significantly, and at the same time, call 911 to explain that you have been pulled over, you are complying, you are concerned about the location, and you are moving to the next safe, well-lit area to stop. You must call 911. You must communicate this directly. You cannot simply drive to a different location without that communication, because driving away from a stop without signaling compliance and informing dispatch can be treated as evading a police officer, which is a criminal offense. Once you have pulled over safely and the stop is underway, all of the same rights apply. But safety and lawful compliance come first, every single time. The officer gets visibly frustrated with your refusal. Go quieter, not louder. Keep your voice completely steady. Don't add arguments. Don't get drawn into a prolonged back and forth. Let him be frustrated. Managing his emotions is not your responsibility in this moment. Your responsibility is to stay calm, stay clear, and stay safe. The calmer you remain while the tension rises on his end, the better your legal position becomes, and the safer the interaction stays. You genuinely don't know what might be in the car. Borrowed vehicle, recently purchased used, a friend had access to it recently. That is an even stronger reason not to consent. You would be agreeing to a search with a completely unknown outcome. Do not mention the uncertainty out loud. That statement, however innocent, can unintentionally create the appearance of suspicion. Just the 5 words, calm and clear. Here is where everything we've covered comes together. That moment, the officer at your window, those 4 words hanging between you. It is a constitutional crossroads. He has, without framing it that way, handed you a choice between a legal right and social pressure, between what the Constitution actually gives you and what feels like the easier exit out of an uncomfortable situation. The answer is 5 calm, clear, legally grounded words. Officer, I don't consent to searches. Not because you're hiding anything, not because you have any hostility toward law enforcement, but because the 4th Amendment was written for this exact moment. Because the people who drafted it understood from direct experience that the power to search without restraint is one of the earliest features of a government that has stopped respecting the people it governs. That protection exists. It belongs to you. Using it is not a crime. It is precisely what it was designed for. When they ask, it means they need your permission. The question itself is proof that you hold something in that moment. Do not give it away without understanding what you're giving. Know the exceptions. Probable cause, valid warrants, lawful arrests, genuine emergencies. These are real, and when they genuinely exist, stating you don't consent won't stop everything. In those situations, do not resist physically. State clearly that you do not consent. Let the record reflect it. Then let an attorney address what follows. Know the tactics: the casual ask, the inevitability framing, the nothing to hide argument, the extended stop, the angry reframe, the canine announcement. These work on people who never saw them coming. You see them coming now. Have the words ready, not vaguely remembered, actually ready, automatic. Available even when your heart is pounding and there are lights in your mirror and a stranger in uniform is standing 2 feet from your window waiting for your answer. And remember, always, above everything else in this video, that getting home safely is the only goal that matters in that specific moment. Not making a point, not winning an argument, not educating anyone on the side of a road at midnight. Get through the encounter safely. Keep your legal position clean and clearly stated. And if something was done unlawfully, that is what courts exist for. That is what attorneys are for. Let the legal system do its job. The people whose lives got complicated by what started as nothing, a brake light, a drifted lane, a registration sticker, they weren't doing anything wrong. They were just unprepared for a question they didn't expect, in a moment they didn't plan for, with pressure they had never been trained to handle. You are not unprepared anymore. But here's what you need to think about before you close this out. This video covered the consent question, the moment before things escalate. But what about what happens after you've already said no, and the officer decides that the way you paused, or the way your voice shifted slightly, or the completely normal nervousness that any innocent person feels when they're pulled over at night, becomes the thing he writes down as justification for what he does next? Because there is a specific documented pattern where an officer attempts to build the reasonable suspicion he didn't have at the start, not from anything he found, but from the way you behaved during the stop. Your hesitation, where your eyes moved, the fact that your hands were unsteady because you were nervous, like any reasonable person would be. These observations sometimes get written into a police report as behavior consistent with criminal activity. How do you protect yourself from having your own completely innocent reactions used against you? How do you recognize in real time when that is exactly what's happening? And what do you say and what do you not say when the questions shift from the traffic violation itself to how you've been acting during the stop? That is what we're breaking down next. And once you understand how it works, you'll realize that knowing your rights is only half of what you actually need. The other half is understanding how those rights can be quietly worked around even after you tried to protect them. Don't miss it.